I'm Lori Leskin. I'm a partner in the consumer products practice area. Some of the latest developments we're seeing in consumer products litigation really focus on some of the environmental and social claims that is coming out. Consumers are finding ways to make their voices heard to companies, and they're trying to enforce what they see as the right way to go on the companies that they're litigating against. And so we're seeing a broad range of claims focused on company advertising, taking statements about aspirational goals and trying to apply them to specific products. We are seeing a lot of claims related to sourcing of materials, and particularly where those materials are sourced in countries that permit or allow child labor. And it's become a social issue for consumers here to make sure that the products they are buying are not being sourced in ways that they feel violate social norms. It's been interesting to watch how the courts are ruling on these types of cases. Like anything in the legal world, it really is very much a mixed bag. We've seen a lot of cases survive the initial motion to dismiss. For example, the Starkist tuna, 100% dolphin safe claims have been allowed to proceed past the motion to dismiss stage. On the other hand, we are seeing some courts be a little bit more discerning and require plaintiffs to make allegations that pass the initial plausibility test. So, for example, in the Allbirds litigation, there were claims challenging Allbirds' environmental sustainability claims and challenging Allbirds' happy sheep type claims. And what the court recognized is the claims regarding the environmental impact were not false. They may have disagreed with how Allbirds was calculating their environmental impact, but what Allbirds said was not false. And the court didn't allow those claims to proceed. More recently, we saw it in one of our own cases, in a PFAS case brought against our client, Cody. The court recognized that PFAS is a wide range of chemicals that have a variety of potential health effects, and recognized it is not sufficient for the plaintiffs to simply claim PFAS without alleging a specific chemical that could cause some harm. Arnold Porter is uniquely situated to help our clients navigate the litigation front. We have been working with clients both after litigation has been filed, but really even before they ever get to that stage. As companies navigate the ESG field and try to make their statements known and make their positions known, we need to be very careful that their messaging is consistent. We need to be careful that their messaging is accurate. And we need to make sure that as they move forward in one area, that they're not walking themselves into a consumer litigation and exposing themselves to class actions and litigation costs. And of course, we're well suited to defend cases that are brought to litigation. I think our recent success for Cody in its PFAS litigation is indicative of how we are able to analyze the science, bring the facts together, and put together strong defense for our client and ultimately get the case dismissed.